All right, everybody. A very good evening to you, ladies and gentlemen. I'm delighted to welcome you all to the 43rd webinar of the first series of the continuous webinar series, which is held in English, organized by the Bar Association of Sri Lanka, which has conducted these webinars over the past year or so, continuously without no interruptions. So even though we are all in lockdown in our homes right now, and might not be in the best of places and in the best of times, let's also not forget how important and necessary it is to stay at home and to stay safe. While in the comfort and the safety of our homes, the Bar Association of Sri Lanka has given you, given me, given us the opportunity to be a part of a fruitful discussion and sharpen our skills and enlighten ourselves further by connecting to today's webinar. We would like to thank the Management Committee of the BASL, that is the President of the Bar, Mr. Salia Piris, President's Council, Deputy President, Mr. Anuram Veragoda, President's Council, Secretary, Mr. Rajiv Amarasuriya, Treasurer, Mr. Rajendra Pereira, and the Assistant Secretary, Mr. Pasindu Silva. I would also like to thank the Seminars Committee, the Chairman, Mr. Rajiv Amarasuriya, Convener, Mr. Pasindu Silva, Co-Conveners, Mr. Pandula Vanyarachi, Ms. Ann Devananda, and Ms. Nikini Mapitigama, without whose efforts we will not have this webinar today. So today's topic is custody of minors, law and the process related to it. To discuss the said subject, we have a fabulous panel of experts joining us. And of course, today's panel is extra fabulous because we have an all-female panel on board. So undoubtedly, it will be a very exciting session. I now take this opportunity to introduce the speakers of today. First, we have with us Professor Sharya Scaniwell. She is an emeritus professor of the University of Colombo and has held many senior posts. She holds postgraduate degrees from the universities of Harvard and Oxford. She's a life member of Clare Hall, Cambridge, and has been the Benians Fellow of St. John's College, Cambridge, Inns of Court Fellow, and a visiting fellow of Balliol College, Oxford. She has served as a commissioner at the Law Commission of Sri Lanka and as a board member of the National Child Protection Authority. Her more recent appointments include that of being a member of the National Monitoring Committee on Child Rights and a member of the National Group of Sri Lanka in the Permanent Court of Arbitration and a member of the Advisory Committee to Review Family Law. Next, we have with us Ms. Shamantha Veerakonunambua. She holds an LLB from the University of Colombo and has been in private practice for 35 years. She practices in the areas of civil law, industrial law, and public law. She has also been a resource person at many seminars relating to law. Let me also introduce to you Ms. Preetika Sakalasurya. She is an attorney at law with many years of experience and is currently the Director for Legal of the National Child Protection Authority of Sri Lanka. Next, we have Ms. Mokshini Jayamana. She has 15 years of active practice in the private bar, and she practices in the areas of family law, money recovery, land disputes, and commercial arbitration. Mokshini has held positions of leadership in the Bar Association of Sri Lanka for over 10 years and has been an active member of the Bar Council. She is currently the co-chairperson of the Women's Subcommittee of the BASL and a member of the Committee for the Review of Civil Law, appointed by the Ministry of Justice, and acts as the convener of the Advisory Committee on Family Law Reforms. And now let me introduce to you the moderator of the day, that is Ms. Jerusha Crossathambaya. She has an LLB from the University of London and an LLM from the University of West London. She has been the legal advisor to the Mayor of Colombo Municipal Council 2018 onwards and focuses on the areas of constitutional law, labor law, human and women's rights. She is a lecturer in charge of family law and taught law at the CFPS Law School. So that will be your panel of experts today. To begin with the discussion, I now hand over the session to the moderator of the day. I hope all of you have an informative and an exciting one. Over to you, Jerusha.
Thank you, Ma. Very good evening to everybody who's tuned in. I must mention firstly that it's an honor to be a part of this esteemed panel of women lawyers. It's not often you get to be a part of a all-female group. but this level of experience and expertise, it's a real honor to be a part of this. Today, we are discussing the topic custody and in full custody of minors, law and practice. And to start off, I'd like to invite Professor Scaniwell to lay the foundation as to the development of the law, where the law started, and a little bit about how it is today. So, Professor Scaniwell, over to you.
Thank you. I'd like to make a few points about parental custody before we continue. The first thing I'd like to stress is the multifaceted nature of parental custody. Parental custody, of course, goes far beyond just the physical custody of the child. It means that it covers the day-to-day life of the child, educational decisions, medical decisions, of course, subject to minimum standards laid down by the state. Secondly, the important concept of upper guardianship. So parental or state custody is always subject to upper guardianship of the court. This was incorporated in the court's ordinance number 19 of 1889 and the later Judiciary Act. Now, I stress on upper guardianship of minors because in the absence of legislation, this has become the mechanism really for developing the law and moving away perhaps from some of the stringency of the common law principles. And I'd just like to mention in passing two UK cases lately where this concept was used. One was the Charlotte Wyatt case, which dealt with a child who was very severely brain damaged. And the issue was whether the very invasive medical treatment that the parents wanted should be permitted or whether they should remove the child from this kind of treatment. And the court took the view that the child should not be permitted, should not be subjected to this very invasive kind of treatment, and thereby showing us the sort of the power of this concept of upper guardianship. And then very soon afterwards, there was another case, NHS Trust versus Indy, where a child had certain responses. The child was also severely sick, but the court decided that it should not be removed from a ventilator because it was showing some signs of recognition and feeling and things like that. So this, of course, is a very important kind of jurisdiction of the court. I'll move very briefly to consider the governing common law principles, which are really Roman Dutch law principles. One was is the preferential right of the father to custody during the subsistence of the marriage. And the second one is the innocent spouse's right to custody on divorce. Now, the important thing about these Roman Dutch law principles is that they have been whittled down by the courts. If you look at the 1950s, we see we see some of the early cases there, which were really the high watermark of the Roman Dutch law. So you see Ivaldi versus Ivaldi, Fernando versus Fernando, both judgments of Justice H.N.G. Fernando, where he emphasizes the Roman Dutch law principles. And you have to place yourself at that particular time, just after independence. There was a rejection of English law and a kind of resuscitation of Roman Dutch law. But of course, that trend changed. And then you find the 1960s, the 1970s, where the Roman Dutch law principles are not given this kind of emphasis. And there is a movement away. You see that in Kamalavati versus De Silva. You see that is, of course, the judgment of Justice Tambaya. You see it in the very important case of Justice Veeramantri in Fernando, versus Fernando. And this culminates in the judgment of Justice Shirani Tilakavardhana in Jayarajan versus Jairajan, where she says that the modern Roman Dutch law has moved away from the earlier standards, and the best interest of the child has become the predominant standard. Now, subsequent to that, you find the statutory recognition of this principle in the Sri Lankan law in the Iccpr Act of 2007, where the best interest standard becomes the applicable standard. It is mandatory and justiciable. And of course, earlier, you had Section 621 of the Civil Procedure Code, which will be taken up by another speaker, where again, there was a movement away from the Roman Dutch law principles. Now, the Iccpr Act of 2007, it is really a strange place to find an articulation of the best interest standard, because if you look at, say, South Africa and the UK, you find this standard articulated in the Children Acts. But here you find it in a sort of general act. But anyway, the important thing is that the standard has received statutory recognition. Now I move to what I think are the gaps in the law. Now the gaps in the law are first that there is no clear articulation of the components of the best interest standard. That has been statutory addressed in South Africa and the UK, and it is now the subject of consideration by the Family Law Advisory Committee. It was also addressed by the Law Commission and the Family Law Committee in 2010. So this lack of a clear articulation of the best interest standard really means that the judge has a very wide, almost uncontrolled discretion. And so the purpose of this clear articulation is to make that discretion a much more guided kind of discretion. Now, the other gap, as I see, are that the components of this best interest standard is also inadequately addressed through the formulation of principles by the judiciary. Now, you can contrast this with, say, for example, South Africa, which also was quite late in coming up with the Children Act. But prior to that, you found a lot of guidelines being articulated by the courts. It started through a case called Mccall versus Mccoy. And this really emerged way before the Children Act of South Africa. Now, the sort of components that were judicially developed were things like concepts of joint custody, the principle of minimum disruption in a child's life, the importance of the child's wishes, which in turn, of course, requires dismantling of existing barriers and the creation of mechanisms for obtaining the child's true wishes. All this had been developed in the South African courts prior to the legislation. So in a sense, the legislation was a sort of culmination of this process. Of course, it was very detailed legislation that emerged in South Africa when it comes to the ingredients of the best interest. But the process had started really a long time before that. And then the final sort of two gaps that I would like to highlight is first, what are the principles that are going to applicable in the case of a dispute between a parent and a third party? How strong is the natural parent's right? And to what extent has the best interest principle permeated into that law, because here you're dealing with a different type of situation. It is not a dispute between parents. It is a dispute between a parent and a third party. We have some early cases where there is a heavy assertion of the natural right of the parent. I think you would recall Ranvanica versus Painter, Samarasinghe versus Simon, strongly in favor of the natural parents' right. And to some extent, such a position would undermine the best interest standard. Other authorities, perhaps Prutnik versus Fernando, Premavati versus Kudalikoda, those would be ones perhaps in which the natural parent's right is not asserted quite so strongly. Now, if we look at this position and we compare it to two cases in the UK, J versus C and Ray M in the UK, you see the UK courts have also had to grapple with this. When can you really interfere with a natural right of a parent? So in J versus C, the case of the child born to Spanish parents who was taken by English foster parents, and what happened after that, the child had become so integrated into the British family that the court did in fact interfere with the Spanish parents' rights, and in a sense gave a much less significant place to the unimpeachable parent concept that had grown in England. The Spanish parents were in no way could you find them to be faulty or anything like that. It was just that the child had integrated into another family and had grown up and had the values of that family. And for that reason, the courts felt that it would be difficult or it was unwise to interfere with the present custodial arrangements. You found in Ray M, the UK just doing almost a roundabout turn. And there again, the facts were very similar. Child had been brought to England, was very much a part of an English family life, and was returned back to South Africa to his natural parents, who it was obviously going to be a very, very different life for the child. And the case, of course, was much criticized. And my final point is that our law has not really responded to the rights of the father of a non-marital child. What kind of custodial rights, what kind of rights of access. This happened again in South Africa through judicial decisions like Bethel versus Bland and Chaudhry versus Valley, where the best interest standard trumped over the applicable principle in that situation, which is that the mother of the extramarital child is the custodian, deemed to be the custodian of the child. So with those observations, I would like now to pass on to the other speakers. So thank you.
Thank you very much, Professor Scaniwell. I think, like Professor Scaniwell pointed out, the English law, much like the South African law, both in statute and in case law, puts forward a direction, a list of things. It's called a welfare checklist that you can look at when deciding on the best interest or the welfare of the child. Things generally like physical, emotional, and educational needs, which parent can or which guardian can meet that better, race, gender, background, status quo, where the child gender is. All of these things are in black and white, unlike our law, which gives a wider discretion to the judges. So these are some principles that maybe we'll have to think of going forward, so that we can have some direction when it comes to the best interest of the child. Also, for those not familiar with the case of Ranvanica versus Painter, and this is a very important principle that is etched in our law about the natural parent that Professor Scaniwell went on, gave a few examples about. It's not about best interest all the time. It is that the natural parent, here it was a lady who gave up her child to a missionary school and later on almost immediately regretted it and wanted the child back. So if you look at it from maybe an objective standard, the missionary school may have had a better welfare situation or a tick box than the poorer mother. But our law supports a natural parent. It's not about, it only interferes when there is some danger to life, morals, or health. But other than that, it is in favor of the natural parent, which is also fair, but it sometimes has, it kind of conflicts with the whole welfare and best interest principle. So now to take us, thank you very much for all of that, Professor. Now to give us a more practical side and how this welfare and best interest principle is applied in our laws, I invite Mrs. Unambua, Madam. Please take us through this best interest principle.
Thank you, Jerusha. I must first and foremost thank the Bar Association Seminars Committee for organizing this this webinar, and I'm greatly honored to be a participant, not the least for the reason that this is an all-female panel. Now, I will deal with the best interest, the standard of best interest of the child when considering disputes between parents, since Professor Scaniwell dealt with the other aspects of that. I will deal with what is the standard of best interest, how it is used in our law when the two parents compete for the custody of the child on marriage breakdown, because another speaker will deal with the situation within the marriage. So as Professor set out, traditionally our courts have followed the South African law, and we all know, and we are all very happy about us having moved very much away from the traditional approach. So initially, of course, it was during the subsistence of the marriage, the preferential right of the father. But after, with the breakdown of the marriage, it would have different considerations. But of course, in our law, fairly early, we had the Civil Procedure Code 2, which provided in sections 619 to 622. It provided for the court to make orders in matrimonial cases, interim orders, and other orders as the court deems fit. So this in effect gave the court considerable discretion it could use if it wanted to in deciding what is fit, what it deems fit. Now, most of the cases are dealing with disputes while the marriage subsists. That is, we have Veragoda versus Veragoda, starting with that, which came in the 1960s. I am not going to the pre-1960s era, which was where the courts were very, very persistent in the preferential right of the father. Now, Veragoda versus Veragoda was the case where it's a very nice observation that the welfare and happiness of the infant is of paramount consideration. The very use of the word happiness, as far back as in the 1960s, the happiness of the child, shows that the court, now that was really quoting an English case, or is it a Canadian case, Professor? It was Mccoy versus Mccoy. Where the court considered the mental aspect also of the child when it considered the welfare and the happiness. Now that is from case law, and it says in Veragoda versus Veragoda, the very fact that the court did look at it that way showed that our courts also had started looking at custody from the child's point of view, rather than from parental power and rights. So this was a very welcome turn. And from there, we proceeded on to getting to best interest being recognized in our law. So, and this standard of best interest of the child is what is now used in South Africa, England, and other jurisdictions with which we are familiar. It is also in keeping with the international covenants to which Sri Lanka is a signatory, although I think we still need legislation also in some respects. Now, what is lacking here is, as Professor stated, guidelines for the court. By case law itself, our courts have had in the past developed some amount of guidelines, though it's not really very satisfactory because it depends on the circumstances of each case. But as Professor stated, we do need, I'm also of the view that we do need some guidelines set out in a statute to guide the courts in how to make these decisions, what is to be considered in the best interests of the child. So now after Veragoda's case, what the court stated was that the paramount consideration of the welfare of the child supersedes all other considerations. So that was followed by other cases where the court, when Kamalavati versus De Silva, that was a case where the mother claimed custody of a 5-year-old child, and financial problems had been the cause for the matrimonial dispute. So in that case too, the father claimed the child, but the court considered the circumstances. That is where the father was working away from home and would see the child only for about 1.5 days every fortnight. And the rest of the time, the child was with the grandmother. So considering those situations, the court gave custody of the child to the mother. Then going back again to Veragoda's case, when the mother was awarded custody, in that case the mother was awarded custody, the court in awarding custody, made a point to observe that custody of the child was being given to the mother, not for the reason that the mother was more financially stable, because the mother was in a better financial position. The court said, His Lordship Justice Sansoni stated that he wants to specifically state that it is not these financial considerations which made him award the custody of the child to the mother. So that is also an important guideline when we are trying to figure out guidelines for the decision, for the standard of what is the best interest of the child. Then now you see in Veragoda versus Veragoda and Kamalavati de Silva, the court had considered other considerations other than financial considerations, though of course the financial considerations may be relevant, but they are not major determining factors. And as a reason for that, I would say, is because financial considerations go hand in hand with the duty of support. So the parents who have the duty of support, whether they have custody of the child or not, will have to financially support the child. But in considering custody, there are other considerations which have to be taken into account, such as the happiness of the child, the safety of the child, the security of the child, the emotional well-being of the child. All those are matters that will be considered. Then thereafter, we come to the case of Presia Fernando versus Dudley Fernando, that is Fernando versus Fernando, where the court, now this was a case which involved two children of 3 and 4 years. There the court held that ordinarily the custody of very young children will be awarded to the mother. And the court stated that this was a rule followed in custody matters, which was necessitated by the principle of the best interests of the child. Now that is easily understandable because very young children, as the court stated, have a right, the right to get that care of the mother. So now we have that specified as a rule by the court that unless there is evidence placed to show that the mother is unfit, the custody of very young children will be given to the mother. And I invite the viewers to go, those who are interested in it, to go through that judgment. It has very interesting and very potent observations on this necessity, the requirement, why the children, young children, should be with the mother. It is seen as a right of the children of tender years. So then another principle which has been accepted by our courts in the cases laid down, following South African cases also, is that in deciding on issues of custody, the guilt or innocence of a spouse will not be a major determining factor, although it may sometimes be relevant. So that is also an important factor, because there may be some situations where even the guilt or the innocence, the decision on that may not affect the child at all. So that is also a principle laid down by our case law. Then there is, finally, we have come to Jayarajan versus Jairajan, Her Ladyship Mrs. Shirani Tilakavardhana's judgment, which rejected outright the preferential right of the father as a principle, and very firmly went on the basis of the best interests of the child. And in awarding the child to the mother, that is very interesting, because the father had made various allegations about the mother, and the mother had aborted the second child, the mother was in remand custody. So all these allegations were made, but apparently none of the allegations had been established. And there the court took into consideration the fact that the father had not seen the child for more than 2 years, not even seen the child for more than 2 years, and the court went on the basis of the principle that the paramount interest of the child, the best interest of the child, requires children of tender years to be awarded, the custody of children of tender years to be awarded to the mother, and that there was nothing in this case to show that the mother was unfit. And in this instance, the child, as far as the child was concerned, the court held that the child's parents were the mother and the grandmother, because the child had never seen the father for about 2 years, and that taking the child away from that environment would be disturbing the sense of security of the child. So, and the court also held that if there was to be a change in the life of the child, then there should be cogent and substantial evidence that such a change was necessary for the best interests of the child. So, in my view, that is a very progressive position, where now we find the child's happiness was considered initially, and here the child's sense of security. So these are intangible things. I can't call it things, but intangible quantities. But court is taking them into account. So what is left now is to see how we can, or what should be set out, whether we should set out guidelines or whether we should leave court to decide on its own, or whether we should have statutory guidelines for determining what the best interests of the child, how the best interests of the child is to be assessed. I would say that guidelines should be set down, although they will not be treated strictly as mandatory matters, but guidelines should be set down. And of course, a decision would depend on the circumstances of each case. So these guidelines would relate, my suggestion, to the sense of security, then the personal relationship a child has with the parents, each parent, the particular parent's attitude to the child, then the environment where the child, which each parent can afford to give the child, the sense of security, the safety from any threats of violence. So all those things should be considered, as well as other matters like the capacity to provide education, the intellectual and emotional development, all these matters. So these are matters, I think, which can be discussed and well, introduced by statute to our law. Well, thank you. I think my time might be up, so I'll leave Jerusha to go on to the next speaker. Thank you.
Thank you very much, madam. Just to reiterate that both Professor Scaniwell and Madam Unambua went through the substantive areas of the law, and we see a shift from there being a presumption towards custody rights for the father, him being a presumption towards the father, which sometimes is used even today in police stations. I think it's an old Roman Dutch principle that is now done away with this case of Jayarajan versus Jairajan. And now we move slightly away, more into the process and more into the practical area of how these laws are applied. For example, Madam Number mentioned that now it goes and it looks more at the child's point of view. And in the UK law, we see that if a child is over the age of 9 or over the age of 9, they are also asked for their views on the custody matter. But in our laws, sometimes it is not a mandatory requirement unless we specially make that application. And it is still adjudicated more based on what the parents and the papers put forward by the parents and their attorneys. When it comes to the practical side of asking for custody, there is two methods. One that is where you pray for custody alongside divorce, or where you seek custody alongside divorce, which is covered by the CPC. And it looks at the whole principle of the district court being the upper guardian and making the final decision when it comes to children. And then where custody is prayed for separately and where divorce is not prayed for at that point, which is looked at under the Judiciary Act. I think we can all agree that custody sometimes is a highly contested area. It is sometimes weaponized as a part of the divorce proceedings, and only the children stand a lot to lose. There is also many instances where this is dragged on for over a period of time. And it's also a very subjective thing when you see best interest. I had a case where the mother alleged that the father was extremely negligent because he would take the child on his motorbike. So there is two sides to that, because for some of us who don't find that extremely scary, it's a normal thing. And if you own a motorbike, then that's the only way you're going to take your child around. But for someone a little more conservative, it could be different. So those are things the judges have to decide on at that point. And we also see this forcible removal, or this, we don't call it kidnap because it's by a parent, but we're also part of the Hague Convention, where if there is forcible removal, you're supposed to return the child, and you can't illegally hold the child without and deprive access to the other parents. So we're going to invite Mokshini to take us further on the practical aspects of these things and tell us how it is in reality versus what the law has to offer. So Mokshini, it's all yours.
Thank you. Thanks, Jerusha. And thank you to all the speakers who laid the foundation, Professor Scaniwell and Mrs. Unambua. Thank you so much, madam. You've really set the stage for what Mrs. Preetika will be talking about and what I will be talking about. Okay, so let's get down to the nitty-gritties. Everyone can see and hear me, I believe. Jerusha?
You are clear, Mokshini, go ahead.
Okay, right. Okay, so, right, now if we go into the custody of a child, when it comes to making an application in court to get custody of a child, right? Now, what's important to note is, okay, let's go down to the brass tacks, right? Now, a child is born to a woman after intercourse with a man, right? Now, that child might be born within a marital relationship. That is, the child might be born to the child's biological parents, will be either within a marital relationship or outside a marital relationship, right? Now, those days, our birth certificates insisted on specifying whether our parents were married or not. But last year, there was a lot of media coverage given to the fact that the new birth certificates, that the new formats that are going to be introduced is going to do away with that altogether, which I think is an extremely progressive move. And I think it's long overdue, if you ask me. But what I will say is that because of that, we're going to be able to see the stigma attached to children being born outside wedlock slowly being removed from society. So that's a very progressive step, right? Now, the reason I'm talking about this is because it's important for us to understand the difference between biological parents within a marital relationship and outside the marital relationship. And also, you get parents who are not the biological parents of the child. Okay. Now, I'm going to refer to certain sections, provisions of the Civil Procedure Code, and I will also be talking about the Judiciary Act, which are the two main pieces of statute which deal with custody of children. If we now consider, first and foremost, getting custody of a child within a marital relationship. Let's say that the two are married, the husband and the wife are married, right? The only time an issue with regards to custody comes up is only when there is a dispute between the two parties. The husband and the wife are fighting over the custody of the child. And that is also most often when the marriage has deteriorated to such an extent that it ends up in divorce proceedings being initiated in the district court. Okay, now I'm just going to be sharing my screen right now, and I'm going to be, before that though, we need to understand that there are two aspects of custody. You get the legal custody and you get physical custody as well. Okay, so legal custody is when a person is able to make the decisions, the important decisions pertaining to a child. For example, signing for the child's, for an application for the child's passport, entering a child to a school, things like that come under the ambit of legal custody. Whereas physical custody is self-explanatory. It's basically having physical access to the child or being the custodian of the child physically. All right. Now, if two persons in a marriage and they have children, and the marriage comes to a point where they end up in divorce proceedings, the Civil Procedure Code actually provides for an opportunity for the parties to make an application to court for custody, right? I'm just going to be sharing my screen right now. Okay, so you will see now, this is section 621 of the Civil Procedure Code. And what that basically says is, in any action for obtaining a dissolution of marriage or a decree of nullity of marriage, the court may from time to time, before making its decree absolute or its decree as the case may be, make such interim orders and may make such provision in the decree absolute or decree as the court deems proper with respect to the custody, maintenance and education of the minor child, the marriage of whose parents is the subject of the action, and may, if it thinks fit, direct proceedings to be taken for placing such children under the protection of the court. Okay, lots of legal jargon there, but essentially what that says is, if two parties come to court for the dissolution of marriage, the court is empowered to make orders either pending the case or at the conclusion of the case for custody. So that custody takes two limbs, like I mentioned earlier. It could either be legal custody or physical custody. All right. But that now, if you notice, it is either interim orders. That means while the case is pending, while the case is being heard in court. And the decree absolute. Decree absolute is the final judgment of court dissolving the marriage. Okay, so the process involved is also interesting. It's very important. Now, Section 619 says that even in any action for separation, the same can be done. So it can either be divorce, or you can even go to court, or two parties can even go to court seeking separation, judicial separation. Our Civil Procedure Code provides for opportunities for two parties to be separated without going through divorce, where the marriage is dissolved. But even in a case for separation, court can grant custody to the party that makes the application. All right. 620 says that even after the decree of separation has been granted, a party can come back to court and ask for that particular decree to be changed. Okay, so it's not carved in stone, so to speak. Even if there is a decree that has been granted, a decree of separation, even after the decree of separation, the parties can come back to court and ask for that order to change. All right. And as the case is pending, because there will have to be an inquiry into that, the court can even grant interim orders pending that inquiry. Okay. Even after a decree is granted dissolving the marriage or declaring a marriage null, still for all, a party can come to court, and it says here, may upon application by petition on summary procedure for the purpose, make from time to time all such orders and provisions, etc., pertaining to custody, maintenance, education of minor children, so on and so forth. Now, let me just stop the sharing of the PowerPoint presentation just to help us to understand. So basically, what happens is two parties file a case in court for divorce. We have what we call interim relief, and we also have what is called substantive relief. Substantive relief is what you get at the end of the trial. You get the case, you get the plaintiff seeks a dissolution of the marriage, and also the plaintiff can also seek alimony. The plaintiff can also seek custody. All right. So at the conclusion of the case, the court will grant what we call the substantive relief, and that substantive relief will be granted by court after a full-blown trial. All right. Now, while the case is pending, a party can also ask for after the case is pending, the court can also ask for a party can ask for interim custody. Now, what that means is that a party can easily come to court, and it's made by way of what we call summary procedure. That means it happens faster than in a regular case. Okay, so what happens is we file a party, even either the petitioner or the defendant can file what is called a petition and affidavit with supporting documentation saying, okay, for these reasons, the child is in danger with the defendant, and therefore I, the plaintiff, I am asking that I be granted custody pending the conclusion of the case. And you can even say, okay, the plaintiff can also say, okay, but the defendant can get the defendant can get access. So custody, if we go back to the substantive relief that a court will grant, the court will grant legal and physical custody depending on what the court decides is suitable after having gone through the entire trial, where the plaintiff and the defendant can put forward the evidence in support of their application. But in addition to that, the court will also grant what is called not just the physical, the legal, but also at the end of the day, the court will also decide as to whether the other party who is not getting full physical and legal custody, the other party can get access to the child. So, for example, if the case is not contested, if it is a divorce, even though in our laws, the divorce laws, we don't have amicable divorces, so to speak, right? The courts have, in their wisdom, made provision through the practice of court to enable parties to come to court and settle disputes, marital disputes, without going into a full-blown trial and establishing marital fault. In those instances, what happens is one party, say for example, if it's the mother who files the case and the mother is the plaintiff, then the father is the defendant, right? So the two parties, they say, the defendant says, I am agreeable to the divorce decree being granted in favor of the plaintiff. However, these are the terms that we have agreed on. And in those terms, okay, technically court does not take cognizance of terms of settlement, so to speak, in a divorce case, but in order to provide for the opportunity for two parties to conclude a case without a trial, the court has allowed for this, right? Legal custody is provided to one person if they have agreed to do so, with access to the other party. So the defendant can say, look, I am agreeable to the plaintiff getting full 100% physical custody, but I would like to have access to the child from, say, Friday evening to Sunday evening. Something like that. So like that, the parties can agree to a suitable access arrangement. Okay. There are instances where even the parties agree to 50% to shared legal and physical custody 50-50. That takes place as well. Okay. So quickly moving on. What we need to understand also is that it's not only within the marital relationship that this takes place. Okay, there are times when even when parties are not married, there are the law does provide for situations where a party can come to court and seek custodial orders. Now, I referred to the relevant provisions of the Civil Procedure Code, and I took you through the relevant provisions of the Civil Procedure Code that provide for an opportunity for a party within a marital relationship to come to court and get custodial orders. Now, there are times when lawyers use the mechanism in the Civil Procedure Code set out in Chapter 48 of the Civil Procedure Code, which is on interim injunctions and enjoining orders. Now, what are interim injunctions and enjoining orders? Now, there are instances where when a divorce case is filed, pending the case, while the case is going on, while the trial is going on, let's assume that the father has full custody of the child and the mother has access. So let's assume that the court has granted an interim order by which the mother can have access to the child from, say, Friday to, or let's say Monday to Friday. Okay, but it comes to light that the child undergoes some form of harm while the child is in the mother's care. Now, in those instances, the father can come to court and again by way of summary procedure, which is by way of petition and affidavit and supporting documentation, tell court, Your Honor, my child is in danger while he is in the custody of my wife, the defendant. Therefore, I am because she takes my son with her to maybe she has a hazardous job. Okay, so while he's there, his life, there's a threat to his life. So he can ask, the father can ask for an enjoining order and an interim injunction by which the court prevents the mother from taking the child to this hazardous location while the child is in the mother's care. So lawyers sometimes use the mechanisms that have been provided by the legislature in terms of Chapter 48 of the Civil Procedure Code to get interim injunctions and enjoining orders preventing one party to a divorce action from doing something that would be prejudicial to the child. So that also is, in a sense, a form of custody or access. So these are different tools that the law has provided to parents, biological or otherwise, to gain access or custody to the child. Mrs. Unambua walked you through the basis on which the judge will arrive at these decisions. And as Professor Sharya Scaniwell and Mrs. Unambua demonstrated to all of you, now the law has progressed and evolved to such an extent that the paramount consideration is the best interests of the child. And the court is empowered to make decisions in the best interests of the child because the court is what we call the upper guardian of minor children. Children below the age of 18, the court, the district court, is considered to be the upper guardian. That means the district court has greater parental rights, so to speak, than even the parents of the child. So whatever the judge decides trumps everything that even the parents say. So that's why we say that the court is the upper guardian of the child. I will not go into the process involved in deciding what kind of evidence. So for example, when evidence is being adduced to prove that one parent is more capable than the other parent to have custody of the child, that parent will have to provide proof of how the child is happy with that parent and how that parent takes care of the child. So there will be things like bills demonstrating the expenses that the parents have incurred, that parent has incurred in maintaining the child, pictures of the child having fun, where they've gone. Sometimes, we in court, we produce even report cards of the child to show that, while the child is in this particular party's custody, he has thrived, he has done well in school, things like that. And then you can also bring evidence before court to prejudice the mind of the judge against the other party, where the other party, the person making the application can say, look, while the child is in this person's care, these things have happened to the child, so therefore we believe that the full custody should be given to me and not him, that sort of thing. It's very unfortunate, like Jerusha pointed out at the beginning, that in very many divorce cases that the parents sadly use the child as a leverage, and they use the custody of the child as leverage to get suitable orders that are beneficial to them from court. So the child is kind of thrown from pillar to post, and through a very long drawn out litigation, it is only the child who suffers, and the mental and emotional trauma that a child has to endure through this is unspeakable. It could be irreversible. So it's actually, we...
Sorry to interrupt. Yes. This in the interest of time, you have about 2 minutes more.
Sure. Okay, so quickly moving on. So that is with regards to cases which come under the purview of the marital relationship, right? But interestingly enough, even though the Civil Procedure Code does not provide for any means of getting access or custody to children outside the matrimonial relationship. So the Civil Procedure Code, beyond divorce actions given in Chapter 42, no party can come to court and get custodial orders from court. However, there are provisions given in sections 582 to 594, Chapter 40 of the Civil Procedure Code, which provide for situations where the child needs a curator to manage the child's property. And one of those sections in chapter 40 of the Civil Procedure Code also provides an opportunity for a person who has been appointed the curator of the child's property to also seek an order of court to be made the guardian of the child. So only in those very limited situations does the Civil Procedure Code provide for a party to make an application in terms of custody for a minor child. But the Judicature Act, let me just now share the provisions of the Judicature Act just for your knowledge. Yes, so the Judicature Act number 2 of 1978 established what is called the family courts. And in the family courts is basically the district courts of the country, right? Now, the family courts have been empowered by virtue of the Judicature Act to make orders as is set out in the act that you see before you right now, in the slide before you right now, to make decisions with regards to the guardianship, custody, so on and so forth, adoption, so on and so forth of the child, right? And the applications for the custody of the minor child or the spouse, or, you know, so basically the family courts through the Judicature Act number 2 of 1978 has been, the district courts have been called the family courts, and the family courts have the power to make these decisions, okay? And, but however, there was an amendment that was brought in terms of Act number 16 of 1989. Now, what Act number 16 of 1989 does is it completely repeals Chapter 5 of the Judicature Act. And instead of family courts, you have what you see in front of you, small claims courts that have been established. So it looks like the legislature has completely abolished the concept of family courts through Act number 16 of 1989, which is an amendment to the Judicature Act. However, as you will see, now in the Act, if you can look at subsection 2 of section 24, it says an order made under subsection 1 shall not have effect until it is approved by Parliament and notification of such approval is published in the Gazette. Now, the Gazette is Gazette number 678 of 14, dated 5th of September 1991. And this particular Gazette only says that Act number 16 of 1989 shall come into force, barring these particular sections. And the section by which the Chapter 5 of the Judicature Act was repealed is Section 13 of Act number 16 of 1989. So in other words, this Act number 16 of 1989 has not come into effect. Now, all that legal jargon to say that still for all, there is the district courts can function as family courts, but lawyers are reluctant to make applications under the Judicature Act because there is this ambiguity in the law. We're not sure whether the judges, if the other side takes up a preliminary objection, then we open ourselves up to the possibility that the case will be completely dismissed in limine from the beginning. But having said that, because it's the interest of the child, and as the court is, as I mentioned earlier, considered the upper guardian of minors, courts are very reluctant to completely dismiss cases that have been filed under Chapter 5 of the Judicature Act in the district court. So therefore, we actually see that judges entertain these applications. And these applications are made not just by the biological parents, but by third parties as well. For example, I appeared in a case where the mother of the biological mother of the child had been missing for 2-3 years and was in the custody of the grandmother. The father's whereabouts were not known. The father didn't want to have anything to do with the child. The child was with the grandmother, but the mother suddenly reappeared on the scene and filed a case under the Judicature Act in the District Court of Montlavinia to get custody of the child. The courts and I appeared for the grandmother, and I took up that preliminary objection. cutting a long story short, finally, because the parties arrived at a settlement, the matter didn't have to proceed any further. But this is basically an overview of the possible angles, the possible methods and tools the law provides to parties to get custody of children, not just custody, but access to children as well. I'm not going to, I'm going to conclude now. Yeah, go ahead.
Is that it? Can I?
Sure, go ahead. Thanks, Jayarajan.
Thank you, Mokshini, for running us through the practical sides of both the civil law under the Judiciary Act and the CPC. Now I invite Mrs. Sakala Surya to guide us through the Magistrates Court kind of arm that works with the Children and Young Persons Ordinance, the Tsunami Act, and custody at that level. Madam, you can unmute yourself. The floor is yours.
Thank you, Jerusha. Custody of minors in the Magistrates Court level. There are a couple of legal provisions that are applicable at the Magistrates Court level that deals with custody of minors. One is Children and Young Persons Ordinance, which was enacted in 1939. This piece of legislation basically deals with the establishment of the juvenile magistrates courts and the juvenile offenders and children in need of care and protection and the institutions that deal with the subject. In the Children and Young Persons Ordinance, child is a person below the age of 14 years, while the young person is a person below the age of 16 years. So now let's look at the situation. During the investigation, police would identify that a child or a young person that comes across is in need of care and protection. What is the meaning of care and protection? What is the meaning of in need of care and protection? It's explained in section 34 of the Children and Young Persons. It's relatively a broader concept. Victims of abuse and who are vulnerable to abuse, that is potential victims too, are included in the meaning of in need of care and protection. It clearly states a child or a young person who having no parent or guardian. Then the next one is parent or guardian unfit to exercise care and guardianship. Then the third category is parent or guardian not exercising proper care and guardianship. And the child or the young person is either falling into bad association or exposed to moral danger or beyond control. Then in that case, this child is in need of care and protection. And the second category is if the child or the young person is a victim of a scheduled offense under the CYPO. The scheduled offense is defined in the CYPO as offenses against the bodily injury to the child or to the young person. These offenses, the bodily injury, the offenses that causes bodily injury varies from 345 to 296, sexual harassment to murder. So, it covers a very wide range. And if a child or a young person lives with a victim of a scheduled offense in the same household, then the third category, where there is a convict of a scheduled offense, lives in the same household as the child or the young person, then this child is in need of care and protection. If the officer in charge of a police station who comes across this type of a child while investigating a case, then he has a duty to, he has a legal obligation to inform the probation officer of the area under section 17 of the CYPO. He has to inform the probation officer the date and the time that he is planning to bring the child before the juvenile magistrates court, and the reason why he is bringing the child or the young person before the juvenile magistrates court. And the police officer is expected to prepare a report on his findings of the investigation on the nature of the vulnerability or the issue, then the probation officer will come to the courthouse with a report. It's called social inquiry report. This report is expected to carry information on the home surroundings, school record, health, and character of the child. All this information will assist the court to come to a decision pertaining to ensuring the protection of this child who is in need of care and protection. If the court is satisfied that the person is in need of care and protection, if the court is satisfied that this particular child or the young person is in need of care and protection, then the court can make orders. There are a wide variety of orders that the court can make. One is court can order him to be sent to an approved or a certified school if the child is above the age of 12 years, or commit him to the care of any fit person. Fit person need not be a relative or a non-relative, but that person should be willing to undertake the care of the child or the young person. Then the next order is order placing him for the supervision of a probation officer not exceeding 3-year period. Now, all these provisions are pertaining to care and protection, children in need of care and protection. Then there are certain provisions in the Criminal Procedure Code. Section 452 of the Criminal Procedure Code speaks about 2 types of custodial orders. That is for anyone below the age of 16 years. 2 types. One is these orders are to be made for custody pending inquiry or trial. That means it's for juvenile offenders. Custody under a probation officer. The second one is custody in an approved home, approved and gazetted by the minister in charge of the subject. Now I will come to discuss about responsibilities of the probation officer or the fit person who will be having the supervision or taking care of the child with the orders from the magistrates court. They have the responsibility to visit and receive reports from the child or the young person who is under supervision, see that the conditions of any recognizance entered into by or in respect of the child are being observed, make reports to the court on the behavior of the child or the young person, advise, assist, and befriend the child or the young person with regard to the education, with regard to finding suitable employment, and if it's necessary, and if it's for the best interests of the child or the young person to do so, to make arrangements to send the child to a certified school or to an approved school, or commit him to the care of a fit person. Now, these are the broad outline of the order made under the Children's and Young Persons Ordinance. Then the next law that applies in the Magistrates Court is the Tsunami Special Provisions Act, which came into operation in 2005, Act number 16 of 2005. The devastating natural disaster took place in 2004, made many children and young persons left without adequate parental care. So it became necessary for the legislature to legislate to protect children and provide adequate care. Legislature enacted Tsunami Special Provisions Act, streamlining and legalizing the existing foster care concept, because this foster care concept was already there in the Sri Lankan context. The Tsunami Special Provisions Act had catering for children as well as young person. Children were the people below the age of 18. Young person were the people between 18 and 21. Applications of the provisions of the Act were for children and young persons who became orphaned due to tsunami, left with a single parent, and who were in need of care and protection, remaining parent unable to provide that care and protection required for the well-being of the growing up of those children and young person. And if I may go a little bit down on the provisions of the procedures and the provisions of the law, anyone wanted to be a foster parent could make an application to the magistrate's court, where he's residing, in the prescribed form of the schedule to the Act. And this application was referred to the evaluation of the suitability of the foster care applicant through the National Child Protection Authority. Foster care evaluation panels at provincial level was established, 7-member multidisciplinary team. Provincial heads of probation department, education and health were there. And apart from that, pediatricians, psychiatrists and psychologists and NCPA were the other members. Panel called a home study report on the mental health of the applicant, on their social, religious and financial backgrounds, and their suitability to be a foster parent. And an evaluation criteria of the foster parent was given in the law itself. That made the procedure easier for the evaluation. The best interest of the child was the paramount importance throughout the statute. Based on the recommendations of the evaluation panel, the court appointed the foster parent. The court obtained the consent of the child if the child was above 10 years of age. Then the court, while making the order of appointing the foster parent, appointed a monitoring officer. The duty of the monitoring officer was
I'm sorry to interrupt. You have 2 minutes more. We're trying to go into a Q&A session. Thank you.
Thank you. Then the monitoring officer would monitor the discharge of duties. So duty of the foster parent was to be a natural parent to act as a natural parent for the foster child. At 18, the child can decide to continue or move away from the foster parent system. If he desires, he can continue up to 21 years. The foster order was for 1 year, evaluating annually, and the court would extend the order annually. NCPA was the guardian of every child left an orphan and every child kept in foster care due to tsunami. This act will cease to operate in the near future once the youngest member reaches 21 years. So, but the provisions in the provisions of evaluation and monitoring of the custodians is excellent. The legislative provisions are exemplary. So we are looking forward to carrying forward these provisions in assessing the custodians when we have to develop laws pertaining to the children's child protection in disaster situations in the future. I hope this will give you some light as to the magistrates court procedures pertaining to the custody of the children. I thank the Bar Association for giving me this opportunity and the Chairman Child Protection Authority for allocating me for this program. Thank you so much. Thank you.
Thank you very much, Madam. Because we're running out of time, I'm going to go straight into the Q&As. And if any of the panelists want to add anything after they answer the question, please go ahead, because I don't think we'll have time to do a different round. I'll start with Professor Scaniwell. Professor Sharya, the question posed to you is this concept of shared parental responsibility or shared custody, which is seen more in other jurisdictions, while as in the Sri Lankan process, they think of one person taking over physical custody and the other person having mere access, and it's not always an equal footing. What would your thoughts be on introducing shared custody as the go to, and only if there is no space for shared custody, thereafter going to physical custody for one party and access for another. What are your thoughts on this, Professor? And you can add anything that you may have left out.
Could you just, in summary, repeat that?
Yes, Professor. This concept of shared custody or shared parental responsibility, which is seen in the English law and other concepts, is not seen as a first step here. It is seen more here when we go to court. In the DC, it's seen more as one person having physical custody and the other person only asking for access. So it is one of the things that has been suggested as a reform that should be brought in as a reform, because then there is a more balanced access for both parents. And the ideal situation is at a stage of separation or divorce that both parents have equal sort of custody. So what are your thoughts on this being proposed as a first step, and only if there is no space for this shared custody that we move on to physical custody being mainly with one party and access just a few days or a few hours access to the other?
Yes, well, shared parental responsibility, as you know, was brought in by statute in both South Africa and the UK as an alternative, in a sense, to custody, because custody was seen as a very bitter process, and I think that has come out in this seminar. So the idea of joint parental responsibilities, there is no winner. You know, there's no one winning a custody case. Both parents have shared parental responsibility, and you have two models. You can have shared parental responsibility as being automatic, and then there is only a movement away from that if you can prove in court that that joint parental responsibility should not be given to one of the parents. Or you can have a situation where you apply for shared parental responsibility. So there are sort of two models. And the advantage is that, you see, it goes on this premise that both parents really must have assumed responsibility for this child. And that is the best method for, even though the marriage may have broken down or the marriage may be in trouble or whatever, they are still the parents. And that there must be a level of cooperation and that they must proceed on that basis. It would be a very good introduction into the law, but it is a fairly new, it's a new concept. We have to move away from this whole idea of looking to see who is the better custodian and all of that, because you start on the premise that both parents have a right to continue in looking after and rearing the child. I think it would be a good concept, but it is something where it will be something fairly new into the Sri Lankan legal system. It's a sort of step upwards from joint custody, which Mokshini pointed out is happening to some extent by agreement. So it's going one step beyond that.
Thank you, Professor. Yes, my next question is to Madam Unambua. The question is, when you were talking about definition of tender age, someone has asked in practice, what could that age be? And I have a second question because it's a short question. On a birth certificate, if the party named as the father is not the biological father, but just married to the mother, then who stands to have rights over this child at any given point? How does it interplay with the adoptive father and the biological father? How do rights interplay? The first question is about this tender age that you brought out in Fernando versus Fernando. What is the age that is used in practice?
In one case, 3 years and 4 years. 3 and 4 years were considered tender age. Then in another case, 5.5 years was also considered young age, where the mother was given custody. So I take the view that anything below 6 years might be young age, when the child needs help to do even daily, his or her daily activities. That would be a young age where the child would need the care of someone, constant care, so that the mother would be the person whom court would naturally choose. So that would be the answer. Courts have considered 3, 4, and 5.5 in the cases that I have cited. Then your next question was
about birth. I'll repeat it, madam. It's about birth certificates where the person married to the mother is mentioned as the father, even though he's not the biological father. How do these parties' rights play out when it comes to rights of the child, their rights over the child?
So where this presupposes that the marriage has ended and the mother is contesting this, because saying that the father is not the biological father, although the name is on the.
That's exactly the question they have asked. You can also touch on how does the biological father's rights also come into it. That's exactly the question they've asked, is contesting the name on the certificate when this marriage comes to an end, because he's not the biological father.
Well, I think there is case law. I don't know whether professor can help us with this. I don't have a reference to the birth certificate, but in the case of illegitimate children, the mother has the right to custody. But here where the father's name was given in the birth certificate, I think it would be only fair that the father should be given the choices or the options or the rights of a biological father. After all, the father gave his name in the birth certificate. So I don't know really whether that's how the court looks at it, because I haven't come across this instance. I don't know whether any of the other panelists can help in this instance. But because there is a presumption of legitimacy when the name is given in the birth certificate.
Yes.
So I think those factors might push towards the position that the father should be given, well, I would say, an equal opportunity to claim the custody of the child, given other circumstances also exist in his favor.
Thank you.
But I think any other panelist also might help from someone else also might be welcome on this matter.
I think the presumption of legitimacy is a very relevant consideration here, as Mrs. Unambua mentioned, because you can't just go and sort of say that, although the father's name is on the birth certificate, he is not the father, because the presumption would come into play. And so you would have to rebut the presumption in that case, which requires at least, a standard of proof which is fairly high. So that would definitely be a factor, because otherwise it would be very unfair, really, by the person mentioned in the birth certificate. Because it also may be a way of evading, allowing this person to have certain rights in relation to the child. Why at this stage is it coming up? Why are they contesting it at this point, isn't it? I mean, there are other factors that come in, particularly presumption of legitimacy.
Thank you,
if I
Professor.
can just, if I can just jump in, Jerusha, that of course there would be a bit of an issue if the father whose name is mentioned, or the person whose name is mentioned in the birth certificate as the legal father, he himself no longer wants to assert his rights because he has got to know that the son is not actually his. Then it would change, the whole scenario would change if he is the one who is actually making a claim to court, or refusing to accept custody of the child on the basis that he is not the legal father. Then the paternity would come into play. Then they would have to have a test for paternity and so on and so forth. Yeah.
Sort of a reverse presumption situation.
Correct,
But there it's fairly clearer than where the mother is challenging it. Mokshini, moving on to you, 2 questions again. The first question is about interim relief and substantive relief. Somebody wants you to clear up both interim and substantive relief. I'll let you do that and then I'll ask you your second question.
Okay, so sorry if it wasn't clear during the presentation, but substantive relief, like say for example, substantive relief would be the final relief that you're asking at the end of the case. So if you have filed a divorce action, your substantive relief would be for the divorce to be granted in your favor, for custody, 100% legal and physical custody to be granted in your favor, or even alimony to be granted in your favor, right? So that is what you will get at the end of a trial, where you will lead evidence and the other party will lead evidence, and the court looks at all the evidence and then gives a judgment. Interim relief is, while this trial is going on, you make an application to court to get some relief while the case is going on. Like for example, what I mentioned earlier, like if the child is getting access, or if the spouse is getting access during some time of the week and the child is exposed to some kind of harm during that time, then you can ask for interim relief. That is, while the case is pending, ask court to prevent this person, the defendant, from taking the child to such and such a place or exposing the child to any danger, that sort of thing. Preventing, it's preventive. You can ask for interim relief, and through that you can actually get custodial orders pending the case. You can get custody actually pending the case, as provided for in the sections that I demonstrated during the presentation. So that's the difference, I hope. And that is not permanent. The interim relief is only until the case is concluded.
Thank you, Mokshini. I think that was clear. The second question is, in a heavily contested matter, how would one make an application to court for the child's wishes to be heard, to ascertain the child's wishes, or for the judge to meet the child? How would one make that application?
Okay, so it's interesting. We sometimes forget that the law that governs all laws in Sri Lanka is the Constitution, right? And Article 106 of the Constitution actually provides for situations where the court can have a case which has very sensitive matters involved, particularly where family matters are concerned, to actually exclude persons from being present in the courts. If I can just read Article 106, subsection 2, it says, a judge or presiding officer of any such court, in his discretion, whenever he considers it desirable, and there are A, B, C, D. There are 4 instances. The first instance is, in proceedings relating to family relations, exclude therefrom such persons as are not directly interested in the proceedings therein. So the legislature, in its wisdom, has understood that when there are family matters concerned, it's not necessary. So it's an exception to the requirement for proceedings in court to be held in public. Subsection 1 talks about the requirement for proceedings in court to be held in public, so that everybody can be privy to it. But subsection 2 talks about the exception to it, where the court can, in its discretion, decide that certain parties are not allowed. And this also, we can use that, lawyers can use that as a way of making an application to have the case heard in camera, in the privacy of the judge's chambers. And I believe just a simple petition and affidavit to the court. The court can act ex mero motu, but a party can make an application by way of petition and affidavit to basically asking the court to have the minor child's views and perspectives and feelings considered in camera using the provisions of Article 106 of the Constitution, and also appealing to the capacity of the judge to make such orders as the upper guardian of court.
Thank you, Mokshini. Mrs. Sakalasurya, your first question is, how does an unmarried person go about applying to be a foster parent? I know we don't have a foster parenting system except under some of these acts that you mentioned. How would an can you hear me, Mrs. Sakalasurya?
Yeah, I can hear you.
So how does an unmarried person, or is it permitted, go about being a foster parent?
The Tsunami, now at the moment, the foster parenting is only available in the Tsunami Special Provisions Act. There's no other legalized system for foster parenting available in Sri Lanka. So in the Tsunami Special Provisions Act, the preference were given to because the child needed a family, foster parents. So the preference were given to the married couples, and the close family members or next of kin, the friends of the family, were given the priority in the Tsunami Special Provisions Act. It does not bar, but these criteria was used to identify the foster parents, merely because the CRC says Child Rights Convention advocates for the family, not for single parents. That concept, without promoting that concept, the family, mother and the father, that was the intention of the legislature at that time.
Thank you, madam. The second question is, how does a non-related party apply for guardianship, or what is the process for a non-related party to apply for guardianship? Of a child. Yes, of a child.
If you are talking about the foster parenting or
any form of guardian, shall I direct that to Mokshini? Mokshini, I think you were going to cover guardianship. Do you want to?
Yeah, I just touched on it during the. Yeah,
I'll direct another question, Mrs.
Sure.
Madam, I'll direct the next question to you.
Yeah, sure.
So guardianship takes place in very limited situations in terms of the Civil Procedure Code. Like I mentioned earlier during the presentation, guardianship takes place when there is a requirement for the child's property to be curated or to be taken care of. In very limited situations that guardianship is actually granted in favor of a party who wishes to have. So in a situation where the parent is incapable of taking care of the child and the child's property, the parent, him or herself, or a third party can come to court and ask court in terms of Chapter 40 of the Civil Procedure Code to appoint this particular person as the curator of the child's property. But there has to be sufficient evidence to establish that the biological parents are not able or no longer able to take care of the child. It's very limited situations, and that the child also therefore needs someone to be the curator. And also in the limited situation, in that limited situation, that particular party can also seek an order of court to be made the guardian. I can refer specifically to that particular section that is found in section 585. Section 585, subsections 1, 2, 3, 4 would be relevant. I hope that answers the question. But other than that, there's nothing in the Civil Procedure Code. If you need custody outside the marital relationship or party who is not related to the child, it would have to be through the Judiciary Act, Chapter 5.
Thank you, Mokshini. Mrs. Sakalasurya, the next question posed for you is, when there are orders from the JMC, the Juvenile Magistrates Court, that covers custody, and also the parties have sought orders from the DC, have you experienced how they interplay? If there is a certain order in the JMC and then say a slightly different order in the DC, can you tell us how that would interplay and which orders would be followed?
final decision is taken at the district court. Now, the juvenile magistrates court, all those orders are for a very limited period of time. The maximum period, the child protection orders are valid. The maximum period is 3 years. So the validity or the weight of the order is more to the DC order than the juvenile magistrates court order.
Thank you, madam. The next question, and I'll pose it in general, anybody can answer. I think because of the fact that we are running out of time, this can be the last question. Thank you, everybody who took part. I think a lot of questions have come our way. I've tried to cover as many as I can. This is very relevant to the current situation. The question is, with court closures and travel restrictions in place, how is one to get interim orders regarding custody matters? And number two, can one parent refuse to show the other parent the child based on health fears, and in order to protect the child during this pandemic, can one person refuse to show or give access to the other person during this pandemic time? I will leave it open if anybody can. Feel free to answer, anyone who's had this kind of experience.
I'll just sharing from my experience, and also I believe now, Jarusha, the particular circular that has been issued by the Judicial Service Commission permits matters which are urgent in nature to be entertained by the district courts. So I believe that if there are sufficient grounds to establish urgency, then an application can be made to court, and court will actually hear the matter even during the pandemic. So, I mean, of course, it depends on the practical difficulties that each district court is facing, but I believe that that is possible. And there are instances where parties have refused to show the child on the basis that the child is would be placed in some form of danger due to the pandemic, but that would, if it's a violation of an order that has already been issued by court, then you are treading on very thin ice, because the court will not look too kindly to those who violate an order that is already in force. With the only option would be, now, for example, if you're the mother and you have the custody of the child, and the husband has been granted access during the weekend, but you say no, it's no longer safe for you to have the child because of this pandemic, the husband has every right to complain about you. If it's in the district court, file papers for contempt of court. Violating an order of court and being found guilty of contempt of court is very serious. There are penal repercussions. So it would be prudent for you to actually make an application to court on the basis that it is urgent, and ask the court to review the order, the interim order that's already in force, inter partes, that is with the other side also present, and let the court decide what would be the best in taking into consideration the prevailing situation in the country as well. That would be what I
Thank you, Mokshini. Just to add from a couple of my cases during this time, it says urgent. So some of the judges have not been happy to take it up because I think it's more bail and other things that have been seen as extremely urgent. So there is a little delay. People were coming to court for custody. There has been delay in some of the cases, especially for health reasons. And in one of my matters, the mother is a doctor and she refused in-person access because of the pandemic, because the father worked in an area that was a hotspot. So when we came into court, we offered online access, and that is something that the court is willing to look at and support and give orders based on Zoom or Skype and phone calls for that particular period, because I think safety and health concerns are also taking a priority at this point. So a lot of online access orders were also given in a couple of our matters during this time. So yes, it is a genuine concern, and the health and safety is taking precedence over everything else at the moment. I'll just look at one more question to close with. I'll keep that also open. The question is, if at the point of the death of both parents, how is custody decided and who has a sort of priority to take over at that stage? Death of both parents. Anyone wants to take this question? Professor or Madam Nambua?
This interesting. Goes to the grandmother, grandparents.
Well, a close next of kin would get like the grandmother, a grandparent, or aunt.
Anyone wants to add to that?
I think that we have precedents in relation to third-party custody disputes. I think some of those would be relevant. The factors that would be taken into account in the court's determination. But of course, an application would have to be made on the basis of the relationship. Or even it is possible that it would have to be based on actually who has assumed de facto custody in that case.
Custody.
And so we would have to go and establish that a de facto custodianship is in the best interest of the child and get a court order as soon as possible, because otherwise, again, as Mokshini has pointed out, I mean, these matters cannot really be taken into one's own hands. One has to really go before court and establish through the urgent proceedings procedure that this custody order has to be made. It could be an interim order or whatever, but some process is needed.
Usually the court would request for a probation report, a report from the probation officer on the family background and the financial and other capabilities of the person who's requesting the custody, or de facto custodian who's requesting the guardianship or the custody of the children. Based on that report, the court would make an interim order. And if there's someone contesting for the guardianship, then the probation reports will be called on each and everyone who's contesting for the guardianship, and the final decision would be
based on best interest. Best interest would come in at that point, at the point of the order.
Thank you very much. It has been a really fun and fruitful discussion. I want to thank Professor Scaniwell, Madam Unambua, Mrs. Sakala Surya, and Mokshini for all your valuable input. I've learned a lot myself, and the attendees have been extremely engaging as well. We have a lineup of questions. I think we can go on about this topic forever, but I've been told that we've run about 12 minutes past time. 22 minutes in all. So I want to thank the panel very specially for all of your insights and the attendees for making this an interesting discussion. And so stay safe. Good night. And I want to thank the BASL too for making provisions for something like this. It has been really useful. And as we grapple with restrictions and travel restrictions, I hope we can have more of these fruitful discussions, and everybody stay safe. Thank you and good night.